Hello friends, welcome to my channel. I am Mahendra Subhash Khainar, Assistant Professor in Law at Bharti Vidyapit Yeshwantrao Chavan Law College, Karad, Satara. As we know that the Constitution is the law of the land, it is based on two important principles, rule of law and separation of power. These principles are of foreign origin, but now well established in Indian legal system with flexibility and mutatis mutandis. In India, the constitution has created three wings: Parliament to make the law or to amend the law, Executive to implement and to execute the law, and Judiciary to apply and interpret the law as per the facts and circumstances of the case. This constitutional mechanism is very well established in the spirit of constitution. Judiciary in India has independence from other branches of the state. Judiciary has played active role in catering justice. In initial period, court was conservative and adopted strict construction of statutes. However, particularly after emergency in 1975, the apex court expanded the scope of power of judicial review, which led to judicial activism in India. Now we'll understand the meaning of judicial activism. I think judicial activism means it is a bold outcome of the process called judicial review. It is associated with interpretation of constitution, statutes in the light of prevailing social, economic and political situations. There is no official or prescribed definition of judicial activism. However, in Black's Law Dictionary defines judicial activism as a philosophy of judicial decision making, whereby judges allow their personal views about public policy, among other factors, to guide their decision. Here, the personality of judge has great impact on his decision. Hence, it can be said that it is a judge-made laws. Now we'll understand how the definition has been developed. The term judicial activism first coined by the American historian Arthur Schlesinger in 1947 in his article in Fortune magazine. According to Arthur, judicial activism is a judicial ruling suspected of being based on personal or political considerations rather than on existing laws. Now the question comes, why we need or what are the objectives of judicial activism? It can be answered that it is necessary to have judicial power to mitigate the case to achieve the ends of justice. Judicial activism is the exercise of the will of a judge to make the law in response to legal issues before the court. Without having such power, it cannot transfer or enforce the modern principles and ideas in the Constitution. The ultimate aim and object of law is salus populi suprema lex, that is, welfare of the people is the supreme law. Therefore, judicial activism is necessary. While seeing judicial activism in Indian perspective, we should understand the Supreme Court in India initially was very conservative in its decisions. However, this led to failure of constitutional spirit, which has been seen in many cases like ADM Jabalpur, A.K. Gopalam and others. Therefore, it was necessitated to have judicial activism in India. Judicial activism is also necessary because there was a chaos due to literal interpretation of constitutional provisions such as Article 359, 368 in different rulings like A.K. Gopalan, Shankari Prasad, Sajjan Singh, Golak Nain and others, which gave rise to confusion, as judiciary was reading only the black letters of law and was ruined the concept of justice as enshrined under the constitution. On the backdrop of these confusing and impairing rulings, the episode of national emergency and political crisis was going on in the nation. This has shaken the minds of constitutional believers. It resulted in their judgment, like Kesavanand Bharti, which propounded the doctrine of basic structure of the constitution, which cannot be amended. In Indira Gandhi versus Rajnarayan, the theory of basic structure was applied, and it was affirmed that it is an integral part of the constitution and most importantly, the dissenting judgment of Justice H.R. Khanna in ADM Jabalpur paved the way to judicial activism. Many other factors were also responsible for the birth and development of the concept of judicial activism in India, such as the national emergency proclaimed by Indira Gandhi in 1975, the doctrine of political question, which was discussed while reviewing unjust exercise of power in proclamation of President rule, insertion of 9th Schedule and 31B, public interest litigation, and such many other protectionist approach adopted by the apex court in interpreting provisions like Article 19, 20, 21 and 32. The concept of judicial activism triggered in 1964 when Justice Gajendra Gadkar has become Chief Justice of Supreme Court. He was known to be a very pro-labor. In his several rulings, his personal views are imprinted and it developed as a judge-made law, which subsequently carried on in other cases. For example, in Golaknath, the court held that fundamental right cannot be amended, whereas this view was later on changed in 1973 in Kesavanand Bharti, where 13-judge bench overruled Golaknath and held fundamental right can be amended but not the basic structure. However, what are the basic structure is not clearly mentioned. It left on the discretion of the judges. This doctrine of basic structure is an outcome of judicial activism. It can be seen in large number of decisions, particularly while interpreting Article 21, which reads as no person shall be deprived of his right to life and personal liberty except according to procedure established by the law. Earlier, in A.K. Gopalan 1950, Supreme Court adopted conservative and narrow view in interpreting Article 21 and held that a person may be deprived from his life and liberty by following the procedure established by the law, which shall be fair, reasonable and just. However, later on in Maneka Gandhi in 1978, Supreme Court introduced the concept of due process by judicial activism. Earlier, procedure established by law may be fair, reasonable and just, but it was decided by administrative authority as to what is fair and reasonable, which resulted in mockery of justice, as we have seen it in Bollywood cinemas like Andha Kanun, Damini and many others. Now, the due process clause gave ultimate power to judiciary as to decide whether decision and decision-making process is fair, just and reasonable. Due to judicial activism, the word life and personal liberty used in Article 21 has been interpreted broadly and liberally, particularly in Francis Corrali's case, where Supreme Court held right to life is not restricted to mere life of animal existence, but it includes the right to live with human dignity and all that goes along with it. This ruling has resulted into expansion of the term life and personal liberty. The Supreme Court read many rights enshrined under Article 21, such as right to live means and includes right to fair trial, right to health, right to legal aid, and many other rights. Many other rights envisaged under Article 21, that is, all the rights that goes along with human dignity now become a right under Article 21. The expansion of the term life under Article 21 now become a limitless. This was done in the light of provisions provided under UDHR, ICCPR, ICACR, international treaties and international protocols. Not only Article 21 received judicial activism, but judicial activism was also there in the area of criminal laws and criminal jurisprudence, which has changed the whole scenario. The concept of judicial activism has been adopted by the apex court in bringing socialist approach in reality. Through variety of its decisions, Supreme Court adopted protectionist approach in cases like MC Mehta, PUCL, PUDER and many others. However, Judicial activism by judiciary has gave rise to conflict. The constitution has created three wings: parliament, executive and judiciary. Powers have been conferred on them are overlapping in nature. Moreover, Supreme Court assumed power of judicial review and proclaimed doctrine of basic structure. This led to conflict of power between the parliament and judiciary. Due to this rising conflict, it was thought that in the name of judicial activism, judiciary is impinging on the domains of other branches of the state. This has developed the theory of judicial restraint, where judiciary and judges have to limit the exercise of their power. It was expected that judges shall respect other branches of the state. In many cases, judiciary itself has promulgated this doctrine of judicial restraint. For example, in state of Rajasthan versus Union of India, the apex court has rejected the petition on the ground that it involved a political question and therefore the court would not go into the matter. Another in S.R. Bommai's case, where judges observed that judicial review is not possible in situations where political elements are dominant. In his public lecture, Justice A.S. Anand, the former Chief Justice of India, has cautioned that judicial activism does not become judicial adventurism. He said that the worst result of judicial activism is unpredictability. Therefore, judges need to be circumspect and self-disciplined. Recently, in 2007, in Divisional Manager Aravali Golf versus Chandarhas in 2007, Justice A.S. Anand clearly mentioned that courts have to function within the established parameters and constitutional bounds. In the name of judicial activism, judges cannot cross their limits. Further, in Common Cause in 2008 case, Supreme Court has referred Professor S.P. Sathe, who in his book Judicial Activism in India, Transgressing Borders, Enforcing Limits. He in his book, while evaluating legitimacy of judicial activism, cautioned against court legislating, that is, court shall not trench upon legislating like a legislature. Many such cases can be cited where apex court itself opined in favor of judicial restraint. To cite, in Rama Muthuralingam 2004, the Supreme Court held that judicial humility shall prevail over judicial activism. Judicial restraint is consistent and complementary to the balance of power among three independent branches of the state. Now we will see difference between judicial activism and judicial restraint. Judicial activism and judicial restraint are two opposite approaches. Please go through the points of distinction mentioned in using color code. We can definitely say that judicial activism have gave rise to judicial lawmaking. Judicial law ought to be the byproduct in individual cases. By judicial activism, altogether give rise to law-making authority to judiciary. As said earlier, the Supreme Court in 2004 in Rama Muthuralingam's case held that the balance of power among three independent branches of the state shall be maintained. It can be done in two ways. First, by minimizing the interbranch interference, that is, judicial respect, which means respect by the judiciary for other co-equal branches. And second, by protecting the independence of judiciary, which means the removal of judiciary from the political and administrative process, which is very well there in the India. To conclude the topic, it can be said that judicial activism can be good if the intention of the court is to protect and preserve rights of citizens and not merely to criticize the government. This is the beauty of Indian Constitution. It maintains system of check and balance through flexibility in its provisions. Hope you like the video. Please like, share and subscribe it. Thank you.